Now at 6, former Milwaukee police officer Michael Mattioli takes the stand in his own defense in his reckless homicide trial.
Our legal analyst Craig Mastantuono from the Mastantuono Coffee and Thomas Law Firm joins us to break down today's testimony. Okay, Craig, the defense called Mattioli to the stand, as we showed folks earlier. Mattioli said he was trying to hold Acevedo down until police arrived and was asked about his conversation with the responding officer. Let's listen.
And the next thing he said to you was, "He's breathing, isn't he?"
Right.
You remember that?
I do.
How did you respond?
I said, I don't know, but handcuff him.
Then why would you respond that way?
Only moments earlier, we were in a real struggle, and I thought he was perfectly fine. I didn't know that he was hurt. I truly did not know that.
And had you known he was hurt or he wasn't breathing, would you have gotten off him?
Absolutely.
Then prosecutors took their turn questioning Mattioli and zeroed in on part of the 911 call Mattioli made in which Acevedo can also be heard.
You've also testified here today that Mr. Acevedo was refusing to leave, correct?
He was.
When you have the 911 call, though, the first words out of his mouth are, "Let me go. My score is not woke. I'm going home." Correct?
I heard that at the 911 call, but I don't specifically remember that in the moment. He was yelling things, but I don't know what he was saying.
In the 911 call, he also states, quote, "I swear I'll go home. I swear." That is early on. What do you remember about that?
I don't remember him saying that in the moment. I heard it on the 911 tape.
What would have been preventing him from going home if he's saying, "I'll go home"?
I was holding him down until the police could arrive.
Okay, Craig, what do you make of Mattioli's testimony? Did he help or hurt his cause?
Well, I mean, with his direct examination, he helped his cause. He was saying, I felt like I needed to do this to get him out of my home or restrain him until police arrived. But he got dusted up pretty good by that prosecution cross-examination that focused on, look, you were on top of him, and he was saying, "I'll go home," and you can hear that on the 911. The prosecutor also went through a series of angry remarks that Mattioli made that are recorded on the 911 to say, you know, you were angry, you were on top of him, and got Mattioli to admit that he was impaired, that he was intoxicated during this whole incident.
Well, let's talk about Mattioli's decision to testify. What's that discussion like between defendants and their attorneys? They have a lot to weigh. By him testifying, does that signify anything to the jury?
Well, you know, first of all, the decision to testify is an ongoing conversation from the beginning of the case all the way through trial between the person accused and his lawyers or their lawyer. There's an old adage among defense attorneys that in a self-defense case, the defendant really needs to get on the stand and testify to say, this is why I was placed in fear for my safety, this is why I had to act out aggressively towards the person, this is why my actions were justified. So it wasn't a big surprise to me that Mattioli testified in a self-defense case. It's a big moment for the jury, and it's always a huge moment when you put your client on the witness stand because you subject him and, you know, open him up to that cross-examination. He waives his right to remain silent.
Before Mattioli took the stand, jurors heard from a former Milwaukee County medical examiner. Dr. Jeffrey Jensen reviewed Acevedo's medical records and autopsy report.
It's my opinion, based on reviewing the video and the antemortem and postmortem photographs, that there's no objective evidence that there was compression of the neck area.
Based on your review of all the materials in this case, did you develop an opinion about the cause and manner of death?
I did.
What is that opinion?
My opinion that the cause of death was prone restraint cardiac arrest, and that the manner of death, in my opinion, was indeterminate.
Yesterday, we heard from the current medical examiner who determined a different cause and manner of death. Is this unique for medical examiners to come to different conclusions?
It's not, and the defense really needed to have an expert opinion that the cause of death and manner of death was different. Here, Dr. Jensen is saying, well, he had essentially a cardiac arrest while on the ground, while being held on the ground by Mattioli. Is that going to be enough to convince the jurors, well, Mattioli's conduct wasn't reckless and therefore a substantial factor in the death? that's still the burden here that the defense has, even though the prosecution has the ultimate burden of disproving self-defense.
So closing arguments tomorrow. We can expect, what, summations of both sides saying how they stated their cases?
Yes, prosecution is going to focus on something I thought that maybe they didn't concentrate on enough today in Cross, which is the amount of time that was elapsing while Mr. Acevedo was apparently restrained in this way, and stretch that out and say this was reckless. This was conduct that disregarded the safety of Acevedo with a tragic consequence. The defense is going to be focused on he was violent. It's undisputed that he was attacking others and he was being held. And he, Mr. Mattioli, called the police himself, therefore evidencing an innocent intent. And I think that's going to be the crucial argument on each side.
A lot to get to today. Craig, thanks for being here tonight. We do appreciate it.